Hi friends, in this video we are going to deal with the important and latest Supreme Court judgments pronounced now in the area of civil procedure, criminal and labor law. To know more about them, please watch the video fully. In the important judgment titled The State of Gujarat and Others versus R.J. Pathan and others pronounced on 24th March 2022, the Supreme Court has held that a High Court cannot direct regularization of temporary employees by creating supernumerary posts. The facts of the case would be that the respondents were appointed on contractual basis for a period of 11 months on a fixed salary and on a particular project. The respondents were initially appointed for a period of 11 months in the year 2004 to the post of drivers. On closure of the project, instead of terminating the services of the respondents, the state took a decision to place them in the services of Indian Red Cross Society. Instead of joining the duties in the Indian Red Cross Society, the respondents approached the High Court by filing writ petition for regularization of their services and absorption in government service. The respondents also challenged their placement with the Indian Red Cross Society. The single judge dismissed the said writ petition. On appeal, the division bench directed the state to consider the cases of respondents for absorption and regularization sympathetically and, if necessary, by creating supernumerary posts solely on the ground that the respondents by now worked for 17 years. Being aggrieved, the state preferred the present appeal with allegation that the division bench committed a grave error in directing the state to consider the case of the respondents for absorption or regularization sympathetically and, if necessary, by creating supernumerary posts. Supreme Court has held that the division bench, while issuing the impugned direction, did not consider the fact that the respondents were continued in service pursuant to the interim order passed by it. The division bench did not also appreciate the fact that the respondents were initially appointed for a period of 11 months and on a fixed salary, and that too in a temporary unit. Therefore, the unit in which the respondents were appointed was itself a temporary unit and not a regular establishment. The post on which the respondents were appointed and working were not the sanctioned post in any regular establishment of the government. Therefore, when the respondents were appointed on a fixed term and on a fixed salary in a temporary unit which was created for a particular project, no such direction could have been issued by the division bench to absorb them in government service and to regularize their services. Further, the impugned direction to create supernumerary posts is unsustainable. Such a direction is wholly without jurisdiction. No such direction can be issued by the High Court for absorption or regularization of the employees who were appointed in a temporary unit which was created for a particular project, and that too by creating supernumerary posts. The impugned judgment and order passed by the division bench showed that what weighed with the High Court was that the respondents were continued in service for 17 years. However, the High Court did not consider that out of 17 years, the respondents continued in service for 10 years pursuant to its interim order. Therefore, even considering the decision of this court in the case of State of Karnataka versus Uma Devi reported in 2006 for SCC 1, the period for which the employees continued in service pursuant to the interim order is to be excluded and not to be counted. The High Court totally missed the aforesaid aspect. No duty was cast upon the state to transfer the respondents to another establishment in a case where it is found that the employees are appointed in a temporary unit and on a temporary contractual basis and on a fixed term salary, and on closure of the temporary unit their services are not required. However, the state was gracious enough to place them in the Indian Red Cross Society, which the respondents did not accept. The impugned judgment and order passed by the division bench is unsustainable and the same is quashed and set aside. However, the order passed by the single judge dismissing the writ petition filed by the respondents is hereby restored. Coming to the next important judgment, titled Premlata allies Sunita versus Naseeb B and others, pronounced on 23rd March 2022. In this judgment, the Supreme Court has held that a litigant cannot be permitted to take two contradictory stands before two different authorities or courts. The facts of the case would be that the appellant, the original plaintiff, initially filed the original proceedings before the Revenue Authority or Tahsildar under Section 250 of MP Land Revenue Code 1959. The Tahsildar rejected the said application, accepting the objection raised on behalf of the respondents, and held that as the question involved in the matter relates to title, hence provisions under Section 250 shall not be attracted. Thereafter, the appellant preferred an appeal. However, pending appeal, the appellant filed the present suit for recovery of possession and injunction. But the respondents filed an application under Order 7, Rule 11 of CPC and requested to reject the plaint on the ground that the suit before the civil court would be barred considering Section 257. The civil court rejected the said application and refused to reject the plaint. Against the said rejection, the respondents preferred civil revision application before the High Court. Pending revision application, the appeal filed by the plaintiff rejecting application under Section 250 came to be dismissed, and it was not pointed out at the time of final hearing of revision application. The appellant filed a review application and the same was dismissed. Being aggrieved, the original plaintiff preferred the present appeals. The Supreme Court has held that the respondents cannot be permitted to take two contradictory stands before two different authorities or courts. They cannot be permitted to approbate and reprobate once the objection raised on behalf of the respondents that the Revenue Authority would have no jurisdiction came to be accepted by the Revenue Authority or Tahsildar, and the proceedings under Section 250 came to be dismissed, and thereafter when the appellant instituted the suit before the civil court, it was not open for the respondents thereafter to take an objection that the suit before the civil court would also be barred in view of Section 257. If the submission on behalf of the respondents is accepted, in that case, the appellant would be remediless. The High Court has not appreciated the fact that when the appellant approached the Revenue Authority or Tahsildar, he was non-suited on the ground that Revenue Authority or Tahsildar had no jurisdiction to decide the dispute with respect to title. Thereafter, when the suit was filed and the respondents took a contrary stand that even the civil suit would be barred, in that case the original plaintiff would be remediless. In any case, the respondents cannot be permitted to take just a contrary stand than taken before the Revenue Authority. Therefore, the trial court rightly rejected the application under Order 7, Rule 11 of CPC and rightly refused to reject the plaint. However, the High Court committed a grave error in allowing the application under Order 7, Rule 11 of CPC and rejecting the plaint on the ground that the suit would be barred in view of Section 257. Therefore, the impugned judgment order passed by the High Court is unsustainable and the same is liable to be set aside. Now we are going to deal with the important judgment titled VIJAY, KUMAR, GHAI and others versus the state of West Bengal and others, pronounced on 22nd March 2022. In this judgment, the Supreme Court has held that a mere breach of contract cannot give rise to criminal prosecution for cheating. The facts of the case would be that an investment was made by the complainant amounting to rupees 2.5 crores, in lieu of which 2,50,000 equity shares were issued. This finally culminated into a memorandum of understanding. Alleging that the accused breached this MOU, 3 complaints were filed. First one, a private complaint under Section 156(3) of CRPC for registration of FIR was withdrawn. Second one is a complaint under Section 68 of the Companies Act, read with Section 200 CRPC filed before CMM, which is pending. Third, a complaint was made to the Central Division Kolkata, which was eventually registered as FIR under Section 406, 420, 120B of IPC. The accused challenged the FIR registered in Kolkata before the Kolkata High Court. The High Court dismissed the said petition. Being aggrieved, present appeal has been filed with allegation that the transaction in question between the parties, as revealed from the FIR, was purely a sale transaction or what may be called as a commercial transaction. Therefore, the question of cheating does not arise at all. The Supreme Court has held that a mere breach of contract is not in itself a criminal offence and gives rise to the civil liability of damages. However, as held by this court in Hridaya Ranjan Prasad Verma and others versus State of Bihar and another, reported in 2004 SCC 168, the distinction between mere breach of contract and cheating, which is criminal offence, is a fine one. While breach of contract cannot give rise to criminal prosecution for cheating, fraudulent or dishonest intention is the basis of the offence of cheating. In the case at hand, complaint filed by the respondent number 2 does not disclose dishonest or fraudulent intention of the appellants. Having gone through the complaint or FIR and even the charge sheet, it cannot be said that the averments in the FIR and the allegations in the complaint against the appellant constitute an offence under section 405 and 420 of IPC. Even in a case where allegations are made in regard to failure on the part of accused to keep his promise, in the absence of a culpable intention at the time of making promise being absent, no offence under section 420 of IPC can be said to have been made out. In the instant case, there is no material to indicate that the appellants had any mala fide intention against the respondent, which is clearly deductible from the MOU arrived between the parties. The simultaneous proceedings arising from the same cause of action, that is MOU, were initiated by respondent number 2, amounting to an abuse of process of the law, which is barred. Whereas the mala fide intention of respondent number 2 is called out from the facts that at the time of filing of complaint, respondent number 2 did not disclose about the filing of 2 complaints at Delhi against the appellants. After filing of closure report by the investigating officer, respondent number 2 filed a protest petition before the CMM Kolkata, where the material fact of 2 complaints was completely suppressed. Further, it is apparent that the complaint was lodged at a very belated stage with the objective of causing harassment to the accused and is bereft of any truth whatsoever. The impugned order passed by the High Court is set aside. The impugned FIR and the proceedings in the file of CMM Kolkata in pursuance of charge sheet against the accused for the offences under section 406, 420, 120B of IPC stands quashed.